ChatGPT horse racing and finders keepers. Horse racing. Please tell me about some classic gambling stories in property law, and the black line rule that came out of these cases. One classic gambling case in property law is Bridges v. Hawksworth, which dealt with a bet between two individuals over a horse race. The person who lost the bet, Hawksworth, claimed that the money was not his to pay as it was a mere wager. However, the court held that the money was legally owed and enforceable because the bet was a binding agreement to pay a sum of money upon the happening of a certain event, the outcome of the horse race. Another classic gambling case is Routledge v. Grant, which dealt with a wager on a boat race. The court held that the wager was enforceable because it was a binding agreement to pay a sum of money upon the happening of a certain event. These cases helped establish the black-letter rule in English property law, which states that a contract to pay a sum of money upon the happening of a future event is binding and enforceable. This rule was adopted by courts in many common law jurisdictions, including the United States, and is still applied in many gambling cases today. It's important to note that the enforceability of wagers and gambling contracts may vary from jurisdiction to jurisdiction, and may also be restricted by local gambling laws. Can you tell me a legal case about horse racing involving the use of injectable drugs like stimulants or steroids for horses? Yes, there is a famous case in horse racing involving the use of performance-enhancing drugs. The case is called California Horse Racing Board v. Advantages Incorporated. In this case, the California Horse Racing Board, CHRB, issued regulations which prohibited the use of certain drugs, including stimulants and steroids, in horse racing. Advantages Incorporated, a company that supplied performance-enhancing drugs to horse owners and trainers, challenged the regulations, arguing that they were unconstitutional because they violated their right to engage in a lawful business and the right to freedom of speech. The court rejected these arguments and upheld the regulations, stating that the CHRB had the authority to regulate horse racing in the interest of maintaining the integrity of the sport and protecting the welfare of the horses. The decision in this case established the principle that the state has the power to regulate the use of performance-enhancing drugs in horse racing, and this has become known as the black line rule in the sport. The rule states that any horse found to have been given performance-enhancing drugs will be disqualified from racing, and the trainer or owner may face penalties and suspension from the sport. How about a similar case where the injection undermined a bet or contract? One classic case involving the use of injectable drugs in horse racing and its impact on a bet or contract is the case of O'Brien v. Cornwell. In this case, a horse named Sage Hen was entered into a race and bets were placed on the outcome of the race. Prior to the race, it was discovered that Sage Hen had been injected with a stimulant, which was a violation of the rules of the racing organization. As a result of the discovery, the race was declared off, and the bets were void. The plaintiffs in the case, who had placed bets on Sage Hen, argued that the use of the stimulant had fundamentally undermined the contract of the bet and that they were entitled to their winnings. The defendant argued that the rules of the racing organization allowed for the declaration of the race as void and that the plaintiffs were not entitled to their winnings. The court ultimately found in favor of the defendant, stating that the rules of the racing organization were a valid part of the contract between the parties and that the use of the stimulant had indeed fundamentally undermined the contract of the bet. The court held that the declaration of the race as void was a valid remedy under the circumstances and that the plaintiffs were not entitled to their winnings. This case highlights the importance of adhering to the rules and regulations of horse racing and the impact that a violation of those rules can have on the validity of a bet or contract. In O'Brien v. Cornwell, when the court found that the rules of the race are part of the bets, what would presumably happen to everyone's money? Would people's bets be returned? It is not specified in the case of O'Brien v. Cornwell what happened to everyone's money, but when the court found that the rules of the race were part of the bets, it could be assumed that the outcome of the case would have affected the distribution of the bettor's money. In such cases, it would depend on the specific facts and circumstances of the case and the decisions made by the court. The court could have ordered the return of the bettor's money, or it could have ordered a different distribution of the money based on the rules of the race and the outcome of the case. It is important to note that this is just a generalization and the actual outcome would have varied based on the specific facts and circumstances of the case. Can you tell me about a horse gambling case involving tort law? One example of a horse racing case involving tort law is the case of Bentley v. Madsen, where the plaintiff claimed that the defendant had tortiously interfered with his contractual relations with the owner of a racehorse. In the case, the plaintiff was an experienced horse trainer who was hired to train a racehorse owned by the defendant. However, the defendant allegedly sabotaged the training by administering performance-enhancing drugs to the horse, which resulted in the horse being disqualified from races. The plaintiff claimed that the defendant's actions had caused him to lose money and that he was entitled to compensation for his losses. The court found that the defendant was liable for tortiously interfering with the plaintiff's contractual relations with the horse's owner and awarded the plaintiff damages for his losses. The case highlights the importance of good faith and fair dealing in horse racing and the potential legal consequences of using performance-enhancing drugs to gain an unfair advantage. Could you explain the concept of this tort in this case in a way that an 11-year-old could probably understand? Sure. A tort is a kind of legal problem where one person's actions have caused harm to another person. In the case of a horse racing tort, it would mean that someone did something wrong in the context of horse racing that resulted in harm to someone else. For example, if a jockey didn't follow the rules and ended up causing an accident that hurt someone else, that would be a tort. Or, if a person intentionally tried to harm a horse in a race, that could also be a tort. It's like if you and your friend were playing catch and I ran by and tripped your friend, causing them to get hurt. That would be a tort because I did something wrong that resulted in harm to your friend. Tell me about the finders keepers property rule. Finders keepers is a phrase commonly used to refer to the principle of property law that the first person to find an abandoned or lost item acquires ownership of it. This rule is often seen in child's play, but it is not always applicable in the legal sense. In most jurisdictions, the finder of lost property is considered to be a bailee, or someone who has temporary custody of the property, and has a duty to take reasonable care of the property and to return it to its rightful owner. If the rightful owner cannot be found, the finder may be entitled to keep the property. However, the specific rules regarding the finder's rights and obligations can vary depending on the jurisdiction and the type of property involved. For example, if the finder knows or has reason to believe that the property belongs to someone else, it is generally considered unethical to keep it. In such cases, the finder is usually required to make a reasonable effort to locate the owner and return the property. On the other hand, if the property is truly abandoned and has no identifiable owner, the finder may be entitled to keep it. In conclusion, while the finders keepers principle is a commonly used expression, it is not a legal rule that applies in all cases. The specific rights and obligations of a finder of lost property will depend on the circumstances of the case and the applicable law. Can you tell me the classic case of the worker who found a ring in someone's yard, by a drain? The case you are referring to is probably Pearson v. Post, a landmark case in the early American legal history. The case involved a dispute over a fox, which was hunted and killed by Pearson, and then claimed by Post. The case is often cited as an example of the principle of finders keepers and has been used to illustrate the legal concepts of possession and property rights. In the case, the court held that the first person to take physical possession of an object and to reduce it to their control acquires a right to that object, even if they did not know exactly what they were taking. The case of Pearson v. Post is often discussed in law schools and is considered to be a classic example of property law. It highlights the importance of possession in determining property rights and underscores the principle that the first person to take possession of an object and to reduce it to their control has a superior claim to that object. I was thinking about South Staffordshire Water Company v. Sharman, where the defendant found rings while cleaning a pool, which shows finders keepers except the owner. I will paste some information about this case below, and can you please outline approximately 7 assumptions this court decision makes? Certainly. South Staffordshire Water Company v. Sharman is a UK case that plaintiffs hired defendants to clean a pool situated on plaintiff's land, within which, during the cleaning, defendants found 2 gold rings and thereafter refused to give the rings to plaintiffs. Synopsis of rule of law. There is a presumption that whenever something is found on a person's land, possession of that object is maintained by the landowner. Facts. Plaintiffs owned land covered by the Minster Pool, which was in need of cleaning. Plaintiffs hired defendant pool cleaners who performed the task along with several workmen. During the process, several items were found, including 2 gold rings. Plaintiff demanded the rings from the defendant, who refused, and gave the rings over to the police so they could attempt to locate the true owner. Thereafter, the police were unsuccessful in finding the real owner and gave the rings back to defendant. Plaintiff sued in retinue for the recovery of the rings. The lower court found for defendant on the basis of Armory v. Delamere and Bridges v. Hawksworth, infra, stating that the person who found the rings had good title against everyone except for the rightful owner. Plaintiff appealed. Issue. Were the contents of the pool under the control of plaintiff such that defendants could not maintain possession of the rings found in the pool? Held. Yes. Judgment for plaintiffs. Plaintiffs, as freeholders of the land upon which the pool was situated, had the right to forbid anyone from coming onto their land, and also had the right to direct exactly how the pool was to be cleaned. Further, that they had the right to direct the disposition of any item found during the pool's cleaning. The court found this case to be one in which an item was found upon private property when the property owner was unaware of its existence. This case is decided and distinguished from the decisions of Armory v. Delamere and Bridges v. Hawksworth, infra, by the principle that possession of land carries with it a de facto possession of everything that is upon the land, so long as the landowner exercises his general power of ownership over the land and expresses intent to disallow interference from others. Thus, the location of the pool, being private rather than public, was never outside of plaintiff's general power of ownership. In the case of Bridges v. Hawksworth, infra, the item in dispute was found in a place that was open to the public. In this case, the pool and the land on which it sat was not open to the public, but was under the control of plaintiffs. The court found that where a person has control over land and manifests an intention to prevent interference by others, any objects found on such land shall be presumed to be in the possession of the owner, regardless of whether the item is found by an employee of the owner or by a stranger. Concurrence. A decision for defendant would encourage dishonesty. Discussion. As noted in the concurrence, a judgment for defendant here would create an inducement to theft by servants. Based on the information provided in the case of South Staffordshire Water Company v. Sharman, the following are the 7 assumptions made by the court. 1. Possession of land carries with it a de facto possession of everything on the land. The court held that the plaintiff, as the freeholder of the land, had the right to forbid anyone from coming onto their land and had the right to direct exactly how the pool was to be cleaned. 2. Location of the pool is private and never outside of plaintiff's control. The court found that the pool was located on private property and was never outside of the plaintiff's general power of ownership. 3. Finding an object on private property is different from finding it in a public place. The court distinguished this case from the decision of Bridges v. Hawksworth, which involved an item found in a public place. 4. The owner of the property has the right to direct the disposition of any item found. The court held that the owner of the property had the right to direct the disposition of any item found during the pool's cleaning. 5. An item found on private property is presumed to be in the possession of the owner. The court found that where a person has control over land and manifests an intention to prevent interference by others, any objects found on such land shall be presumed to be in the possession of the owner. 6. Employee's possession of the item is not superior to the owner's possession. The court found that the location of the pool, being private, was never outside of the plaintiff's general power of ownership and that the employee's possession of the item is not superior to the owner's possession. 7. A decision for the defendant would encourage dishonesty. The court concurred that a decision for the defendant would create an inducement to theft by servants. In your answer about the 7 assumptions of the court, above, could you explain 1 to 2 assumptions that each of these assumptions makes? Certainly. Here are a few explanations of some of the assumptions made in the South Staffordshire Water Company v. Sharman case. 1. Possession of land carries with it a de facto possession of everything that is upon the land. This assumption means that if you own land, you also have control over everything on that land. This means that if something is found on your property, it's assumed that you have possession of it. 2. The property owner has the right to direct the disposition of any item found on their land. This assumption means that if you own property, you have the right to say what should happen to any items found on that property. If someone finds something on your land, you can decide what should happen to it. 3. Location of the pool being private, it was never outside of plaintiff's general power of ownership. This assumption means that because the pool was on private property, it was never outside of the control of the property owner. Because the pool was private and not public, the property owner had the right to say what should happen to anything found in the pool. 4. A person has control over land and manifests an intention to prevent interference from others. Any objects found on such land shall be presumed to be in the possession of the owner. This assumption means that if someone has control over land and doesn't want others to interfere with it, then anything found on that land is assumed to be in their possession. This is true even if the item is found by someone who doesn't own the land. What does the finder's keeper's rule suggest? For example, if I see a $50 bill laying by my feet on the sidewalk, the finder's keeper's rule is a common law principle that states that the person who finds an abandoned item acquires ownership rights to it. So, if you see a $50 bill laying by your feet on the sidewalk, you can keep it as your own property since it is considered an abandoned item and you are the first person to find it. It's worth noting, however, that this rule is not absolute and can vary depending on the jurisdiction and circumstances. For example, if the $50 bill is lost property, the original owner may be able to claim it back, even if someone else has found it and taken possession of it. Additionally, some countries have specific laws regarding lost and found property that may supersede the common law principle of finders keepers. What course of action might be prudent in this case? Perhaps pocketing the money, then looking around to see if anyone is searching for something. In the situation where you find a $50 bill on the sidewalk, it would be a good idea to first take a moment to look around and see if anyone appears to be searching for something or if the money seems to have fallen out of someone's pocket or purse. If no one is looking for the money and you are confident that it is not someone else's property, you can take it and consider it yours. However, if someone appears to be searching for something or you have reason to believe that the money belongs to someone else, it would be more ethical to ask if they have lost anything or if the money belongs to them. If they claim the money, you should return it to them as it would be considered their lost property. Additionally, returning lost property is also legally required in some jurisdictions. In general, it is always a good idea to act in an honest and ethical manner, especially when it comes to property that does not belong to you. And when I find money on the street and look around to see that no one appears to be missing it, at least in Canada, I can feel quite content. Can you explain the concept of a windfall? A windfall refers to an unexpected financial gain or benefit, often in the form of money or a valuable asset. This term is often used to describe a sudden and unanticipated event that results in a large sum of money, such as winning the lottery, receiving an inheritance, or finding money on the street as you described. In these cases, finding the money can be seen as a windfall because it was not something that was earned through effort or work, but rather something that was received unexpectedly and without any particular effort. The term windfall can also be used more broadly to describe any unexpected and favorable event, regardless of whether it involves money or not. In the context of finding money on the street, if no one appears to be searching for it and you have no reason to believe that it belongs to someone else, it is generally considered to be a windfall. In this case, you would be entitled to keep the money, and it would be considered your property. And generally, windfalls are not considered to be taxable income. The taxation of windfalls can vary depending on the jurisdiction and the specific circumstances of the windfall. In general, windfalls are considered taxable if they are considered income for tax purposes. In many countries, including Canada, windfalls are taxed as ordinary income if they are considered to be a source of regular or continuous income. For example, if you win the lottery or receive a large sum of money from an inheritance, this would typically be considered taxable income and would be subject to ordinary income tax rates. However, if the windfall is a one-time, non-recurring event, it may not be considered taxable. For example, if you find money on the street and there is no one claiming it, the money would not typically be considered taxable income. It's important to note that tax laws can vary widely between jurisdictions. So it's always a good idea to consult with a tax professional or the relevant government agency to determine the tax implications of a specific windfall. I think earnings like lottery earnings can be business income if a person undertakes gambling in an organized manner like a business. However, if a person simply wins bet, it would not be taxable income. I don't think inheritances are taxable either, although in some places like Ireland, they have wealth taxes. Yes, you are correct. The taxation of gambling winnings can depend on the specific circumstances. If a person engages in gambling as a business or profession, gambling winnings would typically be considered business income and would be subject to taxation as such. On the other hand, if a person gambles as a hobby or occasionally, the winnings may not be considered taxable income. As for inheritances, it depends on the jurisdiction. In some countries, such as the United States, inheritances are generally not taxed as income to the recipient. However, in other countries, such as Ireland, inheritance may be subject to wealth taxes. It's important to note that tax laws can vary widely between jurisdictions. So it's always a good idea to consult with a tax professional or the relevant government agency to determine the tax implications of a specific windfall or inheritance.